The first thing you should do, if you're able, most people have cell phones, you should take pictures. You should take pictures of both cars, take pictures of any injuries, take pictures of anything at the scene that you might feel is relevant. I have a client that was pushed into a tree. The client took pictures of the vehicle, also pictures of the tree. You should take pictures of the vehicles and the area. But not only that, you have the camera, use it. You should take pictures of the person who caused your accident, the person you were involved in the accident with. You should take pictures of his or her license, his or her insurance card, and any other papers you think that might be relevant. I have a client whose son was injured at school. She filed a report with the school. She was smart enough to take a picture of the report that she filed with the school. So you should use your camera to the best of your ability. Make use of it. You should call 911 and make certain that an accident report is filed. Wait there at the scene. Make sure the officer knows your version of how this incident occurred. And if you're injured, it's very important, pardon me, that you go to the hospital immediately after the occurrence, or to a doctor immediately after the occurrence. Because if you get to court, you don't want to be faced with the question, well, you were so injured that you didn't even go to the hospital or the doctor until 3 days after the event. That negates the strength of your case. So you should take pictures, file an accident report, go to the hospital, and then secure the services of a personal injury attorney who has tried these type of cases. If the insurance company calls you, either the insurance company of the other car, that is, you should not give them a statement under any circumstances. You should tell them that you have an attorney or that you're going to obtain an attorney. Up until the time you retain an attorney, the insurance company for the car that caused your accident is entitled to take a statement from you. You should be aware not to give that statement, that you have the right to refuse. Once you obtain an attorney, they cannot take a statement from you without the consent or presence of the attorney. Once you start going for medical treatment, you should keep a log. Note the day that you went to the doctor, what doctor, how long you were at the doctor, and note what occurred there at the doctor's visits, at the hospital visits, at the MRI, or at the physical therapy session. And you should stay in contact with your attorney and report to him any change in your physical condition and any change in the medical doctors you see, because the attorney has to obtain the records for the medical doctors. Once the attorney starts a lawsuit, the other side, the person responsible for your accident, the defendant, will file an answer. After the answer is filed, the defendant will request a bill of particulars, just particulars about how the incident happened and about the extent of your injury. Your lawyer will respond to the bill of particulars. After the bill of particulars, the defendant will conduct a deposition of you, and your attorney will conduct a deposition of the person that caused your accident, the defendant. After the depositions are taken, the defense is entitled to have you examined by an independent medical examiner, a doctor they hire that will conduct an examination of your injury. So if you have an orthopedic injury, if you broke your arm, the defense will send you to an orthopedist to be examined. If you have if you have a brain trauma, they'll send you to a neurologist or to a neurosurgeon. If you have a heart problem, they'll send you to a cardiologist. Once you have the independent medical examination, all of the discovery is basically done, and at that point, you're entitled to a trial. It's really at the time of trial that these things either get settled or tried.